Well, we'll kick off. Good morning. My name's Andrew Singer, and I'm the head of the construction team at King's Chambers. This is one of the King's construction team webinars. It's on a particular topic. It's a high-level discussion of the Supreme Court's 89-page decision in URS and BDW, which is much awaited. The decision came out on the 21st of May. There were 4 issues in the matter, and we're going to, the 4 speakers who are briefly introduced now are going to deal with those 4 points. We're going to try and do questions and answers at the end. There's a Q&A function that you should have. If you just use that, please, we'll try and deal with some if time allows. We're going to try and be about 10 minutes each. So I'm going to be dealing with the first issue, which was negligence, recovery for negligence and scope of duty. Chelsea Carter is going to deal with contribution points. Oliver McEntee is going to deal with the Defective Premises Act coverage issues. And Jonathan Ward is going to deal with the Building Safety Act issues, namely the retrospective effect and limitation. And just a little bit of background for those of you who haven't yet had the opportunity to plough through the 89 pages of URS. This was a preliminary. This was a trial of preliminary issues. Interestingly, as a lot of you will know, judges always say that they don't like preliminary issue trials, that they're dangerous and they're likely to cause more harm than good and to generate more heat than light. But nevertheless, quite a number of recent hearings have gone to the Supreme Court as preliminary issues, and that means that they're on assumed facts, largely. So this case was on assumed facts, and Lord Leggett, who gave a concurring but different judgment, summarised the facts and the position as follows. The claimant in the proceedings was BDW Trading, the developer of 2 high-rise residential buildings, which were completed between 2005 and 2012. The defendant, URS, is a firm of consultant engineers who were employed under a contract by BDW to provide structural designs. So the key assumed facts were that through assumed negligence of URS, the developments were designed and constructed in a way that created risks to the safety of occupants. That those defects were discovered in 2019, so that's between 14 and 7 years after the completion. That in 2020, BDW carried out remedial works, and it did so, although there was no claim made or intimated against them at that time, and any such claim would, before the Building Safety Act came into force, have been time-barred. And in the action, BDW claimed compensation from URS on 3 alternative bases. The first is the common law tort of negligence. That is not, it's not suggested, it wasn't suggested in the Supreme Court that was a time-barred claim. And the court ordered a preliminary issue trial to decide whether on the assumed facts the losses were within the scope of duty and recoverable in principle. And the judge, who was Mr. Justice Fraser, as it then was, said yes to both of those, that he disallowed a claim for what was described as reputational damage, and his decision was affirmed in the Court of Appeal. In June, as you know, at the end of June 2022, the parts of the Building Safety Act, including Section 135, came into effect, and BDW then applied to amend their statements of claim to allege that because the BSA gave retrospective effect to the Defective Premises Act, the liability to the owners of the flats under Section 1 of the Defective Premises Act wasn't time-barred when the remedial works were carried out, and wanted to add claims under Section 1 of the Act and also the Civil Liability Contribution Act. And the High Court allowed permission to amend, and the Court of Appeal also agreed that permission should be granted and that the new claims were valid as a matter of law and had a real prospect of success. So that's the background. And with that as the background, I'm going to I will now look in about 5 or 6 minutes that are left to me at the negligence issues. The position is, as explained by the Supreme Court, and as I'm sure everyone knows, that in claims in negligence for pure economic loss, which is what this was, it was a claim for the cost of having a defective building which has a lower value than it should have had and or requires repair. And Murphy in Brentwood it has been authority for that proposition since 1991. And there are, in general, no duties of care owed in the tort of negligence, not to cause anyone else pure economic loss. Lots and lots of cases on that. But the main exception is where there's an assumption of responsibility, and that's Headley-Byrne and the Henderson Merritt case. And in this matter, everybody agreed that the exception did apply because URS and BDW had a contract between them. And the reason why the contract wasn't proceeded on was because it was statute barred, the claiming contract, but the taming tool wasn't. So on the assumed fact, it wasn't in dispute that there was a breach of duty of care owed and that BDW incurred repair costs in respect of the developments that were factually, but for caused by the breach of duty. And it was accepted that if, in the Supreme Court, that if the repairs had been carried out before BDW sold the developments, so when they still had a proprietary interest in them, that the cost of repairs would have been pure economic loss, but it would have been recoverable because there was an assumption of liability. But URS said that because the repairs were carried out when BDW no longer owned the developments and because they had no enforceable obligation to do so because at the time they did them, there was a limitation defence, that loss was outside the duty of care and or too remote. But more specifically and importantly, in the Supreme Court, they argued that there was what they called a voluntariness principle, which provides a bright line rule of law, which explains why the loss was outside the duty and or too remote. And it was said that losses are not recoverable because they fall outside the duty assumed by the defendant. They're not of a type and representing the fruition of a risk that it was the defendant's duties to guard against and weren't within their contemplation as a serious possibility at the time the contract was made. So that's Hadley and Baxendale. And before looking at the voluntariness principle, the Supreme Court first looked at what they describe as the standard application to the assumed facts of the law on the scope of duty and remoteness, apart from, and on the standard basis, that they said it was very clear that this was loss that was clearly within the scope of their duty of care. And as far as remoteness is concerned, in a tort of negligence claim resting on a contractual assumption, it's clear that the appropriate test is what has sometimes been referred to as the contract test, as I said before, Hadley and Baxendale. So they said, absence this so-called voluntariness principle, this is clearly a claim that on the assumed facts is made out. So the question then became, is there a so-called voluntariness principle? And the court starts to look at that at paragraph 35 and describes a hypothetical example. There's a passerby who's a DIY enthusiast who notices that there's some solar panels on a newly built but empty house that are potentially dangerous. And he phones the builders and the owner and says, you've got to do something. And they don't. So he comes back a week later and, having nothing better to do, does the repairs himself and then asks the builder to pay for him. And it's clear that if the passerby tries to sue the builder, he's got no claim. And that's because there's no assumption of responsibility by the builder to the passerby and there's no duty of care. So the point that the Supreme Court justices are making at this time, and this is 6 of the 7 judges make a joint judgment on this point, is that the passerby doesn't have a claim, not because he volunteered to do the work, but because it doesn't have there's no nexus between him and the builder. And then point out that in this case, in the URS case, it's hypothetical doesn't apply because there's no dispute that there was a breach of duty. So then they look at 4 cases: the SS America case, the SO Petroleum and Hall Russell case, known as SO Bernicia, the Anglian Water and Crawshaw case, Alhambra Life and White and Young and Partners, And they were asked to decide that those 4 cases establish a principle of voluntariness. And the Supreme Court said that's not correct. The cases don't establish that at all. What is actually established is that it's a fact-specific issue. And as they say at paragraph 55, the most obvious role for a principle of voluntariness is considering whether the causation chain from breach of duty to loss has been broken by the claimant's own voluntary action, or whether, subsequent to the cause of action, the claimant has failed in its duty to mitigate loss. In other words, that voluntariness most naturally falls to be considered within the context of causation or mitigation rather than the scope of duty and remoteness. And those are issues which haven't been dealt with on the assumed facts so far in URS. So those are issues for trial. So the conclusion is that on this point is that there is no rule of law that meant that carrying out of repairs by BDW rendered the repair cost outside the scope of duty owed or too remote. There then a note by the justices on underlying policy, and they point out that the law's focus on the purpose of duty reflects the policy of achieving a fair and reasonable allocation of the risk of loss that has occurred between the parties. And they're happy to say that they think their decision is consistent with those policies. Now, you will have noticed that I mentioned that there were 7 judges in this case. And as you all know, there are normally 5 judges in the Supreme Court. The reason there were 7 was because when the case went to the Supreme Court, one of the issues then in Trey was when the cause of action in negligence arose, because that helped the argument that there was no duty or no loss, because the later it arose, then BDW didn't have a cause of action, it was said, because they didn't then own the buildings anymore. And the Supreme Court were going to be asked to overrule the well-known Pirelli decision, which is, you'll remember, is the case about cracks in a chimney. And so that's why there were 7 judges, because they were going to try to decide whether to overrule one of their own decisions. Now, they decided not to do that because that would have been an obiter decision, because based on what findings they'd already made, the Pirelli point didn't arise actually in the Supreme Court. But they did make some points. The first being that the Pirelli decision was decided on the false premise that cracks in a building is physical damage rather than pure economic loss. But it is a pure economic loss. Secondly, that, however, doesn't mean that Pirelli was wrong. It's saying that when the damage occurs, it's not when it was discovered. And you could have a latent pure economic loss, even though it couldn't have been discovered. And there's some reasoning about that they quote. And thirdly, and notwithstanding what they said so far, in the context of pure economic loss, there are strong arguments of principle for accepting that there can only be actual loss once pure economic loss has been discovered, or could reasonably have been discovered. And they refer to a number of other cases in Canada and Australia and New Zealand. And then they refer to the Latent Damage Act, which would need to be taken into account because that was brought in to try and assist in the Pirelli situation. So they say, well, thank you very much for asking us to decide that, but we're not going to. And so see our next webinar when they do have a proper case to decide that point. But also note now that in building disputes, it may be that no one does come back on Pirelli, because if you have a remedy under the Defective Premises Act, for a claim that arose before June 2022, you'll have 30 years. And for a claim after, then you'll have 15 years. And I strongly suspect that certainly in cases of serious damage to buildings, which is discovered later, the Defective Premises Act will be good enough and people won't need to worry about claims of negligence anymore. Finally, in his speech, Lord Leggett also made the point about causation, whether expenditure should be regarded as incurred voluntarily rather than in consequence of negligence, is a question of causation. which requires a judgment to be made about how a person in the position of BDW could reasonably be expected to act, and does not involve the application of a hard-edged rule of law. It is a question which is highly fact-dependent and can only be finally determined at a trial. So, on the assumed fact, there was a claim in negligence. Thank you very much. I'll hand over to Chelsea now. I'll speak about contribution.
Thank you, Andrew. Good morning, everyone. I'm Chelsea, and I'm going to be dealing with ground 4 as it was dealt with by the justices. Now, ground 4 as it was dealt with by the justices is BDW entitled to bring a claim against URS under Section 1 of the Civil Liability Contribution Act 1978, when there has been no judgment or settlement between BDW and any third party, and no third party has ever asserted any claim against BDW. Now, as Andrew stated, it was not in dispute that the developments had various defects as a result of URS's failure to exercise reasonable care and skill, and the existence of certain of the defects presented a health and safety risk. BDW therefore carried out the repair works to the developments, although there had been no judgment or settlement between BDW and any third party, and no claim against BDW arising out of the defects had been intimated by any third party owners or occupiers of the developments. Now, BDW took the decision to carry out the repair works because it considered that the defects, if left unremedied, presented a danger to the occupants of the developments, and they also risked serious damage to BDW's reputation. The losses claimed by BDW from URS related to the costs of the repair works, of course, together with the associated costs of those works. Now, the Civil Liability Contribution Act enables loss to be redistributed among those liable according to the extent of their relative responsibility for the damage in question. Where 2 or more people are liable, whether jointly or individually to a claimant, the claimant can choose which of those liable to claim against and recover from. The claimant may choose to recover fully from the first defendant and not to recover from the second defendant at all. Such decisions are often made for reasons of convenience, such as choosing to recover against the defendant that is more likely to be able to satisfy a judgment, or, for example, the defendant that has intimated it will not robustly defend itself if a claim is brought against it. But of course, if that was the end of the matter, then the outcome could be extremely unfair. And that is where the Civil Liability Contribution Act comes in. I'll call it the Contribution Act going forwards. The Contribution Act allows the first defendant in such a situation to claim a contribution from the second defendant. Now, BDW, having paid for the remedial works, wished to claim contribution from URS on the basis that they were each liable to the homeowners in respect of the damage remedied. Now, to decide whether BDW could make such a claim, it was necessary for the court to decide when a right to recover contribution arises, and, if different, when time starts to run for the purpose of calculating the 2-year applicable limitation period. Now, BDW and URS's positions on this ground were at complete opposite ends of the scale. At one end, we had BDW contending that the right to recover contribution arises as soon as the damage is suffered by the claimant for which the first and second defendants are each liable, even if the claimant has not claimed or recovered compensation from the first or second defendant in respect of that damage. Now, the Court of Appeal agreed with this contention, and in such circumstances, BDW's right to claim contribution arose when damage was suffered by the homeowners, so upon completion of the developments. Now, at the other end of the scale, URS contended that the right to recover contribution does not arise unless and until the existence and amount of the first defendant's liabilities to the claimant in respect of the damage has been ascertained by a judgment against the first defendant, an admission of liability by the first defendant, or a settlement between the claimant and the first defendant. And of course, in such circumstances, no right to recover contribution had arisen. Now, Lord Leggatt, who gave the leading judgment on this ground, and with whom all the other justices agreed, held that both contentions were wrong, and that the true position lay somewhere mid-scale. Now, in summary, Lord Leggatt concluded that on the correct interpretation of the Contribution Act, the right of the first defendant to recover contribution from the second defendant arises when, firstly, damage has been suffered by the claimant for which the first and second defendants are each liable, and secondly, the first defendant has paid or been ordered or agreed to pay compensation in respect of the damage to the claimant. Now, at that point, but not before, the first defendant is entitled to recover contribution from the second defendant, and the 2-year limitation period begins to run. Now, in reaching this decision, Lord Leggatt analysed the wording of the Contribution Act. I've set out Section 1 of the Contribution Act in full on the slide, with my emphasis added. Now, the parties accepted that the word liable in Section 1.1 is not equivalent to held liable. Now, it has a wider scope and requires only that the person be responsible in law. The use of the words any such liability which has been or could be established in an action brought against him in Section 1, subsection 6, makes this clear. And it follows that proceedings don't have to have been brought for a person to be liable. There simply needs to be a liability which could be established on the existing facts. Now, the court noted that this is reinforced by the wording of Section 6, subsection 1 of the Contribution Act, which states that a person is liable in respect of any damage for the purposes of this Act if the person who suffered it, or anyone representing his estate or dependents, is entitled to recover compensation from him in respect of that damage, whatever the legal basis of his liability, whether tort, breach of contract, breach of trust, or otherwise. Lord Leggatt noted 2 essential features of contribution as provided for in Section 2 of the Contribution Act. I've put up Section 2 on the slide so you can follow. Now, firstly, a contribution is an amount of money. Section 2, subsection 1 states, subject to subsection 3 below, in any proceedings for contribution under Section 1 above the amount of the contribution recoverable from any person shall be such as may be found by the court to be just and equitable, having regard to the extent of that person's responsibility for the damage in question. Secondly, the amount of contribution recoverable under the Act is a proportion, so somewhere between 0 and 100% of another amount of money, as made clear by the wording of Section 2, subsection 2, which states that subject to subsection 3 below, the court shall have power in any such proceedings to exempt any person from liability to make contribution, so a 0% contribution, or to direct that the contribution to be recovered from any person shall amount to a complete indemnity. Of course, that would be a 100% contribution. Now, for a contribution to be ordered, the court must be able to identify an amount of money which the second defendant may be ordered to pay a proportion of. Now, Section 1.2 of the Act states that the first defendant is entitled to recover contribution provided that he was liable in respect of the damage in question immediately before he made or was ordered or agreed to make the payment in respect of which the contribution is sought, even if he has ceased to be so liable since the damage occurred. Now, BDW did not make payment to the homeowners, but it did undertake the repair works at its own cost. Now, it was common ground in the appeal that the word payment in this context includes a payment in kind where it is capable of valuation in monetary terms. And I have placed the reference to the relevant case in that regard, which is Baker and Davis against Leslie Wilkes. Now, an order for contribution must be an order to pay an amount of money. It cannot take the form of a declaration of the respective percentages of the first and second defendant's liability, because a contribution requires a recovery of an amount. And those words are used throughout the legislation: recover, recovery, amount, and amount of money. Now, at this point, the court turned to analyse the Limitation Act, by correspondence, of course, to the Contribution Act. And Lord Leggatt concluded that BDW's interpretation of when the right to recover contribution arises being that the right to recover contribution arises when the damage is suffered by the homeowners, was inconsistent with the relevant section of the Limitation Act, which is Section 10. I've set out Section 10 on the slide. Subsection 3, as you can see, deals with the situation where a judgment or arbitration award has been made. Section 4, or subsection 4, I should say, deals with any other situation. Now, looking at subsection 4, that states, if in any case not within subsection 3 above, the person in question makes or agrees to make any payment to one or more persons in compensation for that damage, whether he admits any liability in respect of the damage or not, the relevant date shall be the earliest date on which the amount to be paid by him is agreed between him and the person to whom the payment is to be made. Now, Lord Legate stated that the only way he could make sense of Section 10, subsection 4, was to interpret it as meaning that in any case where the first defendant makes or agrees to make any payment to the claimant in compensation for the damage, the relevant date is the date when the payment is made, or, if earlier, the date on which the amount to be paid is agreed. As such, time begins to run as soon as there is an identifiable amount of money to which the second defendant may be ordered to make contribution. Now, the relevant date as identified pursuant to Section 10, subsection 3 or 4 of the Limitation Act must be interpreted to match the date on which a right to obtain an order for contribution arises under Section 1 of the Contribution Act. So bringing that all together, in summary, the limitation period for a contribution, for a claim for contribution, starts to run when the first defendant is ordered by judgment or arbitration award to make, or makes or agrees to make, a payment to the claimant in compensation for the damage. So time begins to run as soon as there is an identifiable amount of money or payment in kind with an identifiable value to which the second defendant may be ordered to make contribution. Now, it follows that time started to run for the purpose of BDW's contribution claim on the date when it completed the repair works, of course, subject to the other grounds which were discussed. Now, I just want to note, and it is important to note, that if the first defendant fights a claimant's claim, then it has no right to recover contribution from the second defendant before a judgment is given against itself, the first defendant. So questions of contribution should therefore be decided in the same litigation as the claimant's claim against the first defendant. So don't wait to find out what happens in the claim brought by the claimant against the first defendant. Look to CPR 20.6 and 7. You'll find the correct procedure, follow that, and everything can be dealt with in one set of proceedings. So the practical effects of this judgment on ground 4 is that it reinforces the principle that costs should ultimately be borne by those responsible for the defects by significantly expanding the utility and effectiveness of contribution claims, particularly by developers, to recover costs from negligent professionals and builders. Now, developers will be very happy with this decision, but builders, design engineers, architects and similar professionals, and crucially their insurers, will not be happy about it at all, as the risk of historic liability is real and it is enduring in this regard. So that concludes the summary of ground 4 of the appeal, and I will now hand over, I think, to my colleague Oliver.
So I'll deal now with what was described as ground 3 in the judgment, which is the issue of the construction of the Defective Premises Act, Section 1. And while this is an issue which has equally great significance for parties to construction schemes and to insurers, mercifully, the issues are much less complicated than the contribution issues Chelsea's just discussed. Yeah, so the Section 1.1 provides for the liability of a contractor in the following terms, as you can see on the screen. And under Section 1, subsection A, you'll see that a duty is owed by a person taking on work in connection with the provision of a dwelling, if the dwelling is provided to the order of any person, to that person, and to any person who acquires an interest in the dwelling, to see to it that the work's done in a workmanlike manner or professional manner with proper materials, and so that as regards to the work, the dwelling will be fit for habitation when completed. Likewise, there is a liability on the part of a developer under subsection 4. Anyone who in the course of the business arranges for the provision of dwellings and then sells them on are treated as if they are people who have taken on the work. So this is effectively a statutory exception relating to dwellings to the general principle that mere builders generally owe no duty of care in tort, as Andrew discussed at the outset. And that's where it applies. It effectively creates a transmissible warranty of quality in respect of the matters for which Section 1.1 provides. Very importantly, no liability under the DPA can be contracted out of. That's provided for by Section 6.3. And indeed, notwithstanding the fact that this point has only been finally resolved now by the Supreme Court, the potential liability to commercial parties under Section 1.1a has historically been anticipated to the extent that both the 2016 and 2014 versions of the JCT form, for example, anticipate liability arising under the DPA as between a contractor and employer. You'll see that clause 2.17.2 expressly makes provision for that. It is, of course, right to say that historically, under Section 2 of the Act, Defective Premises Act claims were often excluded where there was an approved scheme. And of course, the NHC Build Mark scheme was historically approved, such as to exclude the operation of Section 1 of the DPA, but that ceased to be the case. So where Section 1 applies, you will have a transmissible warranty of quality that cannot be contracted out of, period. And of course, if that applies to a commercial party who commissions the construction of a building, then that will have very serious implications potentially on the scope of liability, because if the commercial party is able to avail themselves of Section 1, they'll also be able to say, well, we can't contract out of this provision. And equally, it's not simply that you cannot exclude liability, you can't restrict it either. So the caps that apply where the DPA doesn't apply, for example, a typical provision would be 2.17.3 of the JCT form. The caps in relation to consequential loss and so on and so forth simply cannot operate in respect of a liability under Section 1. So on any view, if a commercial developer were able to bring themselves within Section 1, then we have a very significant interference with the parties' freedom of contract. Turning to the issues that arose in URS and BDW, of course, what I've just discussed is all uncontroversial in the case of homeowners, because there's an interest in ensuring that consumers have an appropriate liability target where you've got new or relatively new buildings. But of course, in URS and BDW, we had a commercial developer seeking to avail themselves of it. The statute, as we saw, says they are a person to whose says that the duty can be invoked by a person to whose order the building has been constructed, and BDW said they fell within that. The issues that arose were not confined solely to the issue of whether the developer fell within the provision, but also as to whether or not they could recover the kind of damages sought, and I'll come back to that. The arguments with it in the Supreme Court were relatively self-contained and confined, and I don't propose to go into the detail of them. URS's position was to say, well, it says that the duty is owed to a person to whose order the building's been constructed. But if you look at the statutory background, the purpose for which this provision was implemented was to protect consumers who lack bargaining power, to protect themselves from the exclusion of liability by developers. They said that rationale can't conceivably apply to a commercial developer of land, and it can't conceivably have been intended to interfere with freedom of contract as between commercial developers and builders. They further said that if you look at the scheme of the legislation as a whole, what was intended was a sharp distinction between providers of buildings on the one hand and purchasers on the other. And they further pointed out, as I showed you at the outset, that a commercial developer themselves will be liable under subsection 4 of section 1. And it would be anomalous if you had a situation where such a person were owed a duty by a builder, but themselves were subject to the duty. And what was said effectively was that by implication, commercial developers are excluded from the range of persons who are to be deemed as having ordered building work. And BDW's argument in response really can just be summarised as saying that the provision means what it says. It says it requires one to investigate who ordered the work. If that's a commercial party, so be it. They ordered the work and they're owed the duty. And the Supreme Court essentially agreed with BDW on that. They said that when one considers the context and purpose of the statute, they apply to any person who's ordered the works. That was true as a matter of language, and there were observations on that at paragraph 143. There was no reason why, as a matter of ordinary language, a developer could not be such a person. But there were also some policy reasons which informed the decision. What was said was that effectively, when you look at the practical outcome, if developers are able to avail themselves of Section 1, they're not put in a commercially position which is materially commercially different from the builder themselves. They're exposed to a different claimant, and effectively, if Section 1 is construed in that way, then you have a pass-through, and therefore far from it being anomalous that a developer can both be liable and the beneficiary of a claim under Section 1, it's actually consistent with the entire logic of the statute. There was then an issue raised as to whether or not the type of damages claimed properly could be recovered by a developer, because obviously the range of claims to which a developer is exposed are going to be fundamentally different from those that might be advanced by subsequent owners. The subsequent owners are going to have a claim for defect rectification, perhaps discomfort if the house isn't fit for human habitation, and so on and so forth. But of course, the developer, as the settler of the property, might be exposed to a much wider range of claims, particularly in a Grenfell type scenario where there's a catastrophic personal injury event. But that argument was given extremely short shrift. It was said that once it's accepted that developers fall within Section 1A, then they fall within 1A. And the argument that the kind of loss which BDW said that it had suffered somehow fell outside the scope of Section 1, that simply fell away. One point to note, and it's an obvious one, but just to bear in mind, is that the is an issue as to who's actually ordered the work. But in the case of a situation where there has been an order, it's not actually necessary to show that the developer had a proprietary interest. And the only reason I flagged that up, of course, is that while a developer typically will own the land, that will not always be the case. For example, in the case of a Homes England development, you'll often have state land owned by the state. The developers are brought in to market, develop, build and sell on it, but they don't actually own the patch of turf. Nonetheless, a developer will still be a developer on the grounds that they ordered the work. So that, in a nutshell, is what was decided in relation to Section 1. The only one point to note potentially going forward maybe as to the application of Section 2A, which was introduced to deal with the position of subcontractors, because it's relatively clear that now subcontractors will definitely owe a duty to the person for whom the work is done, and there seems to be no reason to exclude from that, bearing in mind the logic under the decision of Section 1, a commercial contractor that engages them. And equally, under Section 3B, you'll note that Section 3B provides for liability in respect of each person who holds or acquires an interest in a dwelling in the building. Plainly, where work is commissioned by a consumer to build a building for them, there will be a pass-through they will have a direct claim against the subcontractor on the basis work has been done on part of the building and they hold an interest in it. But one point which didn't arise in the instant case but might arise in future is in the case where a developer just so happens to hold an interest in the building, whether they notwithstanding that they're not the person for whom the work was done contractually, are able to assert that they hold, albeit for a limited period of time, an interest in a dwelling in the building, which would not only result in a warranty of quality that can't be contracted out of, but also would allow the contractual scheme to be skipped. That is a matter that needs to be seen. So that's the position on the DPA Section 1 claim, and I'll hand it over to Johnny.
This part of the talk deals with the question of what happens when an expired 6-year limitation period suddenly becomes an unexpired 30-year limitation period. The basic facts have been set out. Essentially, the development was completed in 2008. It was investigated and thought to have serious defects, and the original limitation period under the Defective Premises Act expired 6 years after completion, so around 2014. BDW carried out the repairs in, I think, 2020, 2021, by which time claims under the DPA were out of time. And so when BDW issued proceedings against URS, having done the remedial work, it didn't include claims under the Defective Premises Act. Then comes the Building Safety Act in 2022, and Section 135 is the section that deals with limitation periods and the extension of limitation periods under the Defective Premises Act. I've set out the relevant wording on the slide. Essentially, the limitation period under Section 1 of the DPA is extended to 15 years prospectively and 30 years retrospectively. So causes of action that had accrued already when the provision came into force, when the BSA came into force, now had a 30-year limitation period. And as you've heard, the proceedings against URS were already on foot on BDW's negligence claim, and as was the case in many of these building safety cladding disputes, BDW immediately applied to amend its claim to bring claims under Section 1 of the Defective Premises Act and for contribution from URS. I should say that although this arose in many cladding cases, this wasn't actually a cladding case. But in any event, BDW applied to amend to take advantage of the new limitation period, and perhaps unsurprisingly, URS resisted that application. And it really had two arguments against the proposed amendments. Firstly, it said that the new limitation period, although it applied retrospectively, it couldn't apply to existing proceedings, so where there were already proceedings on foot between the parties. And secondly, it said that on the basis that the negligence claim on URS's case should already have been struck out, this was a matter which was essentially to have been regarded as being finally determined. The TCC judge disagreed with all of that, and the amendments were permitted on the basis that they were reasonably arguable and should proceed to trial. So off they went to the Court of Appeal. I won't spend long on this, but just to note that these initial arguments were determined against against URS by the Court of Appeal, and these arguments weren't pursued in the Supreme Court. So in relation to the ongoing proceedings point, it's the Court of Appeal ruling that remains binding on that. So let's get now to the decision in the Supreme Court. The URS came up with an entirely new argument. It abandoned the earlier argument in relation to limitation. And its new argument was to say that the 30-year period, whilst it applied retrospectively, it only applied to actions brought directly under Section 1 of the Defective Premises Act. It didn't apply, on URS's case, for any other purposes. So, for example, in contribution proceedings, the question is going to arise, are two parties liable for the same damage? And if one party is relying on an alleged liability under the Defective Premises Act to seek a contribution, the extended limitation period is not applicable. That was URS's argument. So the answer in such a case would be, it would be in the negative as regards the contribution claim, because it would be outside of the original 6-year limitation period, even if there's a primary liability under the new limitation period for claims brought under the Defective Premises Act. And if you're slightly struggling with that concept, don't worry, you're not alone. But I'm going to try to elaborate a little by reference to how the Supreme Court summarized the issue. And I've put on the slide a couple of quotations which really frame the issue that was arising under Ground 2. Effectively, URS argued that Section 135 does not apply to collateral or incidental issues or deem prior matters of historic fact to be other than they were. And it poses the question, does the retrospectivity of Section 135 apply to claims which are dependent on the time limit under the DPA, but are not actually claims brought under the DPA? So this next slide also shows how this issue becomes relevant or became relevant to the negligence claim, because you recall there was an issue about whether the repairs were undertaken voluntarily. And so if the limitation period was 30 years and was to be regarded as always having been 30 years, then the DPA claims were to be regarded as always having been in time. That would affect the argument on voluntariness and whether the repairs were done without legal obligation. So it was also relevant to the claim in negligence. Another way to look at the issue is to consider whether there ought to be two separate limitation regimes effectively, because that was the way the Supreme Court characterized URS's argument. Because analysed retrospectively under the Building Safety Act at the time of the repair works in 2020, only 12 of the 30-year limitation period for claims under Section 1 had elapsed. But is it correct that when you consider claims of negligence or for contribution, were those claims to be regarded as having been subject to a limitation period of 6 years, which had already expired in 2014? Well, as can be seen, this is a question of the interpretation of the statutes, and unsurprisingly, that's the way that the Supreme Court approached it and answered the issue. Obviously, the exercise involved determining the intention behind the provisions and the Act itself, and matters of policy to some extent. And it was noted that the central purpose of this part of the BSA, at least, was to hold to account those primarily responsible for building safety defects. And the Supreme Court preferred the interpretation that facilitated that objective rather than frustrating it, again, unsurprisingly. Some further points in relation to the interpretation and the Supreme Court's comments on the purpose of the Act, but I would emphasize that as well as there being a theoretical aspect in relation to the justice between the parties and developers and contractors, it emphasized that there's also very much a practical element in terms of asking, well, where is the money going to come from for repair works? Because if developers can't fund remediation work or are less willing to undertake remediation work because recoveries downstream are doubtful, that risks frustrating the purposes of the Act. So, having considered matters of interpretation, policy, and the like, the resolution was was answering this question as was posed, and as follows: the limitation periods apply to all claims arising by virtue of Section 1 of the Defective Premises Act, and not merely to claims brought directly under Section 1 of the Defective Premises Act. So posing the question again in relation to a contribution claim, are the developer and contractor liable for the same damage? So answering that question, the contractor cannot rely on there being a shorter limitation period than there would be in relation to a claim by a leaseholder against the developer. In both cases, they would be taken under the BSA to be 30 years. But the Supreme Court was careful to emphasize that there's no question of the Building Safety Act changing any historical facts. And what that means, essentially, is that if asking whether the decision to carry out remedial works was reasonable when that decision was taken, so in this case, perhaps 2019 or 2020, history isn't to be rewritten by pretending that the extended limitation period was in effect at that time and influenced the decision. So the question of causation in negligence, insofar as it might turn on the reasonableness of a decision to carry out repairs, remains unaffected by this judgment if that decision preceded the extension of the Limitation Act. In relation to claims for contribution, though, the limitation period is effective, so that the question of whether there was a liability at the relevant time is going to be answered by reference to that longer period. So there's something of a summary of this ground of appeal and the Supreme Court's decision on the ground of appeal on the slide. One point I would just refer to in closing is that there's arguably now a distinction between repair work that was carried out before the effective date of the Building Safety Act and work that was carried out after, at least insofar as claims are brought in negligence, because in relation to the former, questions of reasonableness may well arise in relation to the decision to carry out the work, but for work afterwards, the developer will be regarded as having been under a DPA liability by reference to the new limitation regime. So this part of the appeal was also dismissed. So I think that concludes all of our talks in relation to the four grounds of appeal. We may have a little bit of time for some questions if there are any. I don't think there are any in the Q&A so far, but feel free to drop some in.
Thanks very much to all our speakers this morning, and thanks to the audience for watching. And that was, of course, a very quick canter through four relatively complex issues. I suggest that if time permits, that you read into some of the speeches in some details. And we will make the slides available on our website, and we'll also, put a copy of URS on the website as well, if anybody wants to have a read of it. I think we are actually now out of time. Thank you all for joining us today. We'll have some more seminars in King's, not just on construction, but on all the areas where our specialists know this practice. So have a very good day, and thank you very much for joining us.